Counsel, may I ask for your views about Counsel Paulson's argument that if a state could prohibit abortion in the first term, it could also cap the number of children that a woman or a family wanted to have, or it could prohibit reproduction at all?
No, Your Honor, which is why, as representing the Attorney General and the President in this matter, I was careful to say that the government has no interest in overturning Griswold versus Connecticut or Eisenstadt. But there's a very big difference between intervening before a human life is created and intervening to protect that human life that was created. This court, in the case of Duchesne versus Winnebago County, in my opinion, issued one of the most chilling Supreme Court opinions since Dred Scott. In that case, little Joshua Duchesne was the child of a man and a woman who simply couldn't make their marriage work. Mom left the state after the divorce was entered, divorce decree, and Dad had a violent temper. Little Joshua was in fact the object of that violent temper and was beaten so severely that he routinely appeared in emergency rooms. Now, emergency room physicians do not report that sort of abuse lightly or often, and yet in the case before this court, physicians from 3 different hospitals called Human Services and said, "You must intervene to protect this child." The live-in lover of this violent man also called and said, "You must intervene to protect the life of this child." And yet public officials did nothing more than meet with the father and suggest he expand the number of hours that Joshua was in daycare. Ultimately, Joshua was beaten so badly that he lost the capacity to care for himself entirely and will live the life of a child who can neither speak nor feed himself nor care for himself. He'll be institutionalized for life. In considering whether the government had an obligation to protect Joshua, knowing of the abuse, Justice Rehnquist of this court wrote, "The Constitution does not require the government to intervene in private acts of violence, and there is no constitutional right that was violated by those negligent officials in that case." Your Honors, while we may have to accept that the government doesn't have an obligation to intervene when the life of an innocent child is at stake, it is the position of the government in this case today that we have a right to intervene when the life of an innocent child is at stake.
But counsel, I'm not sure that altogether answers my question. Let me put it simply. If the government can say to a woman, "You may not end this unwanted pregnancy," does it not also have a right to say to a woman, "You must end this wanted pregnancy"?
No, Your Honor. This court was quite clear in Ferguson versus the City of Charleston, I misspoke, Ferguson versus the City of Charleston, that women cannot be forced to subject themselves to some sort of physical exam or direction based on their pregnancy. That would violate the Equal Protection Clause. It would also violate this court's holding that as far as the decision to beget a child, the decision to conceive a child, that must remain outside the scope of government authority. But in this instance, the child has been begat. And what is at issue is whether or not the people of this country, through the normal political process, will once again be entitled to protect that life of that child in the same way that we should have protected little Joshua Duchesne. Thank you, Your Honors.